I've been taught by teachers who are indigenous to the land where I live that it's important that I locate myself when I speak. I am a descendant of mostly white settlers to what is currently called the United States of America. I feel most at home in Northern California, the San Francisco Bay Area, which is Ohlone and Miwok territory. And I currently live in what settlers call Pennsylvania, but the rightful owners of the land, the Lenni Lenape people, call it Lenape-Hawking. I'm currently in Rwanda, and where I am grateful that I've been welcomed with hospitality as a guest. So I'm here today to talk about victimhood and ethics in international criminal law. And I want to say that I introduced myself in the way that I did by placing myself in a context, in part to show that I'm aware that I live in colonized space and therefore implicated in an ongoing problem, a harm, not something that happened a long time ago. So in order to talk about victims and ethics in international criminal law, I'm going to talk about the role victims tend to play in criminal law in general, why that creates a tension for international criminal law, what international criminal law, and in particular the ICC, says its aims are, and how that does or does not help us in dealing with the reality of residing in a world where there are just too many victims of grave harm. And it's a real question about whether international criminal law makes a difference in their lives. So some things I'm talking about today I will simplify, and others I will complicate. So if you get impatient with any of the reductionism, you can talk to me about it later. But legally speaking, criminal law is about order. It's usually about state order. When there's a criminal case in a jurisdiction such as the United States, that case is sometimes called the United States of America versus accused person. And that's because when a harm has been criminalized, it's thought to be something more than a harm against a person. It's thought to be something that a state has an interest in controlling because it harms not only individuals, but the capacity of the state to assert control. So it's about order and control. Wait a second. The arrow's not working. All right. And what that means is that criminal law isn't really about victims, it's about order and control. So we have a tendency to think that things that are criminalized must be more harmful than things that are subject to only civil legal procedures. And that's not necessarily a good thing to think. For instance, in the United States, theft, stealing, is criminalized, but destroying someone's reputation by telling lies about them in public is not. So if you think about what the outcomes of these two kinds of harm might be, you probably will have an easier time surviving having your car stolen than having your reputation utterly destroyed. And I'm not saying theft isn't serious. I'm only asking why we live in a world where theft is probably a criminal offense, but something like libel, ruining someone's reputation, is a civil offense. The answer is that it's because the state has an interest in protecting private property, so stopping theft, but the reputations of individual citizens have less of an impact on the state's capacity to stay in control. Plus, there's an interest in the value of free speech, and that makes making determinations about what type of speech should be outlawed or criminalized fairly difficult. You can think about arguments we've seen about what to do about hate speech. Now, I point this out only so that we have in the back of our minds that criminal law is about control and order, and it's not necessarily about the severity of the offense or the extent of impact on the harmed person. This is going to matter to our discussion, even though the harms that we're talking about when we talk about international criminal law do tend to be severe harms. So criminal law is about order and control, and it also tends to take as its main subject individually criminally responsible people, right? It aims to bring individuals to justice and show that if the evidence can lead us there, they are responsible for real crimes. So it does that by gathering and presenting evidence and following agreed upon rules and procedures, determining guilt and innocence. There's already a problem here, as Kamari pointed out in her opening address. Especially in an international jurisdiction, it's rarely the case that someone is either guilty or innocent, either victim or perpetrator, and it's rarely the case that anyone accused of grave crime acted alone. Things are messy. So let's think about the role that victims can play here. it is usually only to perform as witnesses. That usually means that they can only answer questions posed to them by lawyers. And it means that the questions that they are asked focus on the facts of the case at hand against a perpetrator. And that might be a rewarding experience for a witness, but in many cases it can also be disappointing. Think about it. You and your, or someone you love suffers a grievous loss at the hands of an organized campaign of violence or oppression, and when you finally get a chance to speak about it publicly, you aren't allowed to tell the story that matters most to you. You can only answer questions having to do with a narrow range of legal facts that may or may not have much to do with what you perceive the harm to have been. Now, there are reasons for this having to do with the rights of the accused, and that does matter quite a bit. But let's say that you're a victim or a survivor on the witness stand, and you might want to talk about how what happened tore apart your whole world, or how, even though it has been years since it's happened, your world is nowhere near put back together. And it isn't just you that's affected. It might be your whole family, your whole community. Perhaps no one has what they need to feel safe or to meet daily requirements for shelter and food, let alone healthcare and education, for years. You want to talk about that because those are the harms you've undergone and are still undergoing. Of course, the crimes of which the defendant is accused are also harms, but there you are, sitting on the witness stand, and you're only allowed to answer questions posed to you by lawyers. And those questions are only about whether what is provable beyond a legal doubt, whether it is provable beyond a legal doubt that the defendant did indeed do the things that they're accused of doing. So, what they might be accused of: murder, pillaging, rape, genocide, or torture, and those are tremendous harms. And we need to make sure that people who make them happen are brought to justice. But what those legal harms do is something larger than a legal fact. So let me say this again. And I want to say, this starts with the idea that you are imagining that you might undergo a grievous harm, but I know very well that when we are in a room together, we all have different backgrounds, and you can't tell by looking at someone what it is they've encountered in their life. And in any room that you're sitting in, people have different pasts, which means that they're living the present moment in a different way. And therefore, we should always be attentive to the way in which questions impact different people differently, because of the way that harms from the past carry themselves into the present moment. But imagine that those that you love suffer grievous loss at the hands of an organized campaign of violence or oppression, and when you finally get a chance to speak about it, you aren't allowed to tell the story that matters most to you. You can only talk about legal facts, and which may or may not have much to do with how you perceive the harm to have been. My first question that I'd like to hear, maybe a couple of answers to, is: do you think this would feel like justice to you? Why or why not? What else, if anything, might you need in order for it to feel like justice had been done? And this is a way of asking, what is justice? What is recovery? Are they related, separate, a bit of both? Does anyone want to take a stab at an answer? All right. I won't make you answer this one. So, I'm not assuming that we would all have the same answer to this question. Some might say the answer is yes, this does feel like justice to me. Someone getting what they deserve and ending up in prison is exactly what I want. Others might say, no, this doesn't change anything about my daily life. I need reparations. I need education and healthcare programs for my people. I need an apology from the state that allowed this to happen. I need to rebuild community. I want the buildings that were destroyed and the infrastructure that was destroyed to be rebuilt. All of these things. I want that more or just as much as criminal punishment for the person who did something wrong. So my point is that the experience of being a witness might be cathartic for some, and for others it might bring more pain. For some it might be a bit of both. But a legal proceeding is inevitably going to take a narrow view about what the problem at hand is. I wrote a book that's called Ethical Loneliness, and ethical loneliness is the term I give for the experience of having undergone mass violence and sustained depression, surviving that, and then when you testify to what happened, you don't get heard on your own terms. So the term points to a failure of hearing on the part of those who think they're listening. So not just people that won't listen, but people who think they're listening and are doing a bad job at it. It can happen in courts, it can happen in truth commissions, archives of testimony, survivor support groups, doctors' offices, friendships, anywhere where there may be the hope of being heard and hearing fails. The book also investigates how broad the social responsibility is for recovery from harm. For instance, it feels very different for a survivor to live in a place where people deny what happened, say it wasn't wrong, or tell you that you just need to get past it, than it does for a survivor to live in a place where others who say what happened should never have happened, that it was unjust and wrong, and everybody has a stake in making sure it doesn't happen again. So let's keep in mind that as we think about what we ought to do about justice for victims after harm, how each of us can help create a space where human beings are heard on their own terms. Each of us plays a role in what it feels like to live where we live. States and other large institutions have limited control over that, which means that there's always things we can do even when we're disappointed by our institutions. So I'm saying that criminal law is not really about victims, it's about perpetrators. That's the purpose of criminal law, to establish guilt and hand out consequences. Procedures to guarantee a fair trial to an alleged perpetrator matter. We should also note that international criminal courts have expanded the roles that victims can play in some ways, and I will mention that in a little bit. But right now, let's consider the tension at hand. Can a set of procedures designed to protect, prosecute, and if they are found guilty, punish perpetrators also be a form of justice that has enough regard for victims? Can something designed to be for perpetrators also award justice to victims? Or are we asking too much of one thing when we hope that a court will take care of all of that for us? And that's a rhetorical question. You don't have to answer it right now. So let me say a bit about the ICC, just so that we're all on the same page with regard to its mission. Some of this is pretty basic. In July of 1998, the Rome Statute was adopted by 120 countries. The Rome Statute is the law that governs the ICC. It tells us what the court's jurisdiction is and what rules it can apply. In 2002, it was ratified by 60 countries. That's when it became a law that could be applied to actions that humans undertake. The exact date of the ratification is July 1st, 2002, and that date is significant because the ICC doesn't have retroactive jurisdiction. It can only rule on crimes that happened after that. Historically, there have been calls for international courts at various moments in time, notably World War I and World War II, and there have been various tribunals created to deal with the aftermath of specific conflicts, like Nuremberg and Tokyo tribunals, the ICTY and ICTR tribunals in the 90s. That's the backdrop against which something like the ICC can come into being. It's too soon to say whether, in the history of international relations, the International Criminal Court will have ended up making a difference. 100 years from now, it'll be more clear whether this foray into international criminal law was a failed experiment, a political opportunity, or one step toward shifting, successfully shifting, responding to conflict to law rather than violence or diplomacy. Okay, I'm not going to go into this because I think we pretty much understand it. These are the crimes that the ICC has jurisdiction over, and its jurisdiction is over individuals, not whole groups. The one thing I want to mention about these crimes is that there can be overlap between categories. For instance, at the ICC, Dominique Ongwen was charged with murder as a crime against humanity and murder as a war crime. Same with torture and rape and sexual slavery. He was charged in both categories. He's charged with so many crimes that it took over 20 minutes to read out the charges at the beginning of arguments of his trial. When someone's charged with the same crime in more than one category, it might mean that in some cases the crimes are against civilian populations and in others they're not. Or it might mean that in all cases these are crimes against civilian populations, but committed in such a way that they also violate the laws of war. So the prosecutors charge both crimes so that they can prove it, hoping that they can prove at least one using valid legal evidence. So if you think about it, these are all world-destroying harms. Genocide, crimes against humanity, war crimes, and aggressive war are all ways that human beings find to make the world unlivable for other human beings. And when I say unlivable, I don't only mean killing people, because obviously people who have been killed are finding the world unlivable. But by unlivable, I also mean those who are left alive, but whose whole communities, ways of life, traditions, important practices and sites, whole families, networks of support, possibilities of imagining the future, all of that destroyed. Genocide, mass violence, mass murder, sexual slavery, torture, destruction of infrastructure, all of this destroys worlds. And when I say that worlds can be destroyed, it's also a way of saying that worlds are built. We build worlds by living together in the way that we do. If we're lucky and our lives have been fairly stable and safe, then we might make the mistake of thinking that the way things work, where we live, is just how the world is, and that no one built that, and it just came into being, like a natural structure of the earth or something. But if we back up from that thought just a moment, we'll find that it can't possibly be true. We live in worlds that were built. We inherit what others built in the form of laws, social rules, cultural norms, traditions, conflicts, resentments, and established practices. And we also add to the world by accepting those things we inherit, or by challenging those things and acting to change them, or we add to the world by creating new things. So we help build the world we live in by living in it in the way that we do and contributing to it, or by not contributing to it. How we live with others is part of what makes the world what it is. So international criminal law deals with world-destroying harms, and some of us might think we live in worlds that could never be destroyed, that they're strong enough to withstand whatever we might throw at them. But that, I want to remind you, is the mark of a person who has had privilege or luck or both to be able to believe that. One thing international criminal law does is remind us that worlds can be destroyed. And one thing international criminal law hopes to do is deter people from wanting to engage in destroying worlds. The ICC hopes to have a deterrent force, to be a reason why people don't undertake genocide, crimes against humanity, and the like. In fact, its website says this: the court is participating in a global fight to end impunity, and through international criminal justice, the court aims to hold those responsible accountable for their crimes and to help prevent those crimes from happening again. So the court aims not only to redress harms that have already been committed, but to prevent future harm. And it's hard to know whether it has that power, the power of prevention or deterrence, for various reasons. One is that it doesn't have any power of enforcement, really, so it might not successfully scare anyone away from harmful acts. I doubt Vladimir Putin is sitting around being worried about the International Criminal Court right now. Another is that people committing some of the crimes might just look at the numbers involved. I'm one of 30,000 child soldiers. What are the odds that I'm going to end up at the International Criminal Court? And just not think that it's a risk. Another reason is just kind of logical or philosophical, and that is that it's hard to know whether deterrence works, because it's hard to prove that something caused something else to not happen. Okay, so if I walked into this room today and before my presentation I said, hey, I've got one rule, and that is while I'm speaking, do not harm each other. When I got to the end of my presentation, I would be like, hey, I successfully prevented you from harming each other. But you'd be like, I wasn't going to do that anyway. See, it's hard to prove that one thing caused something else not to happen. So let's get back to what the ICC thinks it's doing. There's been a move in the last few decades in the international criminal law to shift its purpose from only finding individuals criminally responsible for specific crimes to claiming that the purpose of international criminal law is providing justice to victims. You see this in claims made by Antonio Cassese about ICTY. You see it in lots of press releases at ICC and in prosecutorial opening statements and things like that. When these claims are made, they're usually made in the vein of finding perpetrators guilty does justice to victims because they find this gratifying and justice is served. In part because what an international criminal trial does is establish facts in ways that are harder to dispute than some other types of fact-finding. And some victims are gratified by this. But I just want us to remember that this is a weak beginning about what needs to happen in the wake of world-destroying harm. At the end of the day, criminal law still is mostly about apprehending the accused, gathering evidence, running fair procedures, and, if possible, convicting and punishing offenders. It might be nice if it also helped victims. It's also nice that there are now opportunities for victims to have their own representatives at the International Criminal Court. And it's nice that there's a trust fund for reparations for victims available at the ICC. Getting into the weeds of the complexities of that and what is and is not working about it is beyond what I'm going to do today. But I'm sincere when I say that those are good developments. But I'm also sincere when I say that I don't think they do much. So much more needs to be done, and much of that can't be accomplished by legal mechanisms. So, so in terms of the different purposes of trial that the ICC might have, so far we've talked about retribution and deterrence. Retribution being a backward-looking way of looking at things and trying to deal with what happened in the past. Deterrence being forward-looking, trying to deal with what the future might bring. A third purpose that the ICC might claim is expressivist. That would be a way of saying that what judges and lawyers do expresses values, and that makes a difference in terms of showing what ought to be the case. And these are all perfectly fine purposes. Some of you also might have more radical purposes in the way that you think about punishment. You might find yourself, you might be abolitionist, thinking that this way of thinking just isn't helpful to us. You might be more aligned with transformative or restorative justice philosophies, and so you might think that retribution is just not as helpful. I tend to be that person, but I want to also own up to what can be complicated about that, because I tend to think of myself as being abolitionist about retribution, and then I still find myself gleefully celebrating when somebody like Derek Chauvin, the white police officer who murdered a man named George Floyd on video, got and convicted and sent to prison. There I am gleefully celebrating this happening while being an abolitionist. So what could that possibly mean? Well, I think what it is a conflict between long-term and short-term strategy. And these are all perfectly fine purposes. Some of you also might have more radical purposes in the way that you think about punishment. You might find yourself, you might be abolitionist, thinking that this way of thinking just isn't helpful to us. You might be more aligned with transformative or restorative justice philosophies, and so you might think that retribution is just not as helpful. I tend to be that person, but I want to also own up to what can be complicated about that, because I tend to think of myself as being abolitionist about retribution, and then I still find myself gleefully celebrating when somebody like Derek Chauvin, the white police officer who murdered a man named George Floyd on video, got and convicted and sent to prison. There I am gleefully celebrating this happening while being an abolitionist. So what could that possibly mean? Well, I think what it is a conflict between long-term and short-term strategy. Long-term, I'm an abolitionist. I don't think that the way prison works in the United States gets anything done, and I think that's probably true across many different systems of incarceration. But short-term, when I'm living in a society that is deeply racist, especially in its justice system, when a white police officer gets convicted of murder that everybody saw, of course I'm going to celebrate, because it's rare that that happens. So just keep in mind in your own struggles with maybe your own contradictions around justice that short-term and long-term are both honorable goals, because if you only do long-term, you might miss out on some of the short-term harms that are really hurting people right now. But if you only do short-term, you might just be building the system that you don't like without trying to do something more. Okay, so now I want to move on to talking a bit about Dominique Ongwen, because I think it's going to help us think about a little bit about the discussion about what's complicated about the difference between victim and perpetrator in international criminal law. And let's just start by saying many of us may disagree about this case and what ought to be done about it, and that's perfectly fine. I think many of you are familiar with it, so I'll just say a few things about it. Dominic Ongwen is an ex-child soldier who was abducted at the age of 9, brutally indoctrinated into a violent way of life and forced into combat. He allegedly became so good at partaking in the violence that he was promoted up the chain of command of the Lord's Resistance Army in northern Uganda. The ICC indicted LRA leaders such as Joseph Coyne, Vincent Otti, and Dominic Ongwen in 2005. The ICC did not issue indictments for any leaders of the Ugandan state army, and that's already a political decision. So you could say that the Ugandan state, as a signatory to the Rome Statute, self-referred the case of the LRA to the ICC in the hope that the ICC would help solve a political problem that it had. I think most people assumed that none of these cases would ever come to trial because none of the defendants would ever be found alive. And then Ongwen surrendered himself in 2015. And I sometimes wonder whether any prosecutors in the ICC, when they heard this, thought to themselves, oh no, like not this defendant, or whether they were just super excited to be able to try a complex case. International law doesn't tend to charge children with crimes for the same reason most domestic laws don't. There are widespread, though also widely varying, beliefs about agency and responsibility that do not find children capable of making certain types of legal and ethical decisions. It is, of course, more complicated than that. The 20th century gave us a history of political disputes about what children are owed and what they're capable of. Some of the parties to these arguments about children's capacities are proponents of children's liberation, the idea that children have rights and are capable of autonomous decision-making that ought to be respected. Others focus on children's protection, the idea that children are vulnerable in ways that adults are not, and thus deserve special protections. I think both sides are right. Children have agency and are capable of making meaningful decisions, and children are also vulnerable in ways that some adults are not. But let's not also forget cultural difference. Some cultures measure maturity by age and then disagree about what that age ought to be. Others judge it by outward signs of maturity, physical changes in bodies, or the ability to take on new responsibilities. Truth be told, those might be the more accurate ways, but law likes things to be easier than that, so there's a preference for picking an age and just sticking with a universal standard. David Rosen wrote a book about comparing Andrew Jackson, a founding father of the US, who gets called a freedom fighter, but who started battle at age 13, to Ishmael Bea, a Sierra Leonean child soldier who wrote a well-known memoir that has come under controversy about his experiences. The story we tell about those two children is very different. So international legal discourse about child soldiers does show signs of some of these tensions about agency, responsibility, and vulnerability, but mostly it tries to skirt the issue by only charging people with crimes they commit once they've turned 18. That was very pronounced in the Ongwen case. If it happens to be the case that the adult charged with crimes was also abducted, abused, and forced to commit crimes well before they were 18, that is taken to be a question of whether punishment should be mitigated, rather than a question that might make us question the idea of who is responsible for criminal action. So let's think about what we would need to know in order to make a judgment about how this case should be judged. I'm going to talk about some upsetting things in order to give us the context we need to think about this carefully. When children are abducted by the LRA, they're often forced to kill other children, sometimes their own siblings, if they wish to live. They're made to carry heavy loads of materials over long marches and punished if they drop anything. They're given drugs and food. The girls are taken as workers or as sexual slaves. The boys are taken as workers or soldiers. They're taught to think that Joseph Coyne can read their minds so that if they even think negative thoughts about him, they'll be harmed, and so on. So this is the context in which a child soldier turns into an adult if abducted by the LRA. But let's remember this side of the problem too. Ongwen was accused and convicted of committing many serious harms: murder, torture, enslavement, rape, forced marriage, persecution, sexual slavery. These are world-destroying harms. And he was convicted of doing these things to many people for many years and doing them very effectively in a position of leadership. Legal definitions of responsibility tend to assume that we're all capable of what a philosopher would call Kantian responsibility or free will. The basic idea is that since we're able to make rational decisions to do or not do good or bad things, we can be held responsible when we do the wrong thing because we could have done otherwise and we have the capacity to know better. The idea of individual criminal responsibility is built on this assumption that we can be held liable for what we do whenever we know right from wrong and could have done something other than what we did. But here's a question the International Criminal Court does not want to ask. How do we get the capacity to know right from wrong and thus acquire a duty to respect rights and refrain from harm? No one is born knowing right from wrong, and ideas of right and wrong are not the same in every time frame and cultural setting. I want you all to take a moment to think about this for yourself in your own life context. I'm going to have you do just like a couple minutes of brainstorming before I continue. I want you to think about each of these questions, and you can jot something down. I'm not going to have you hand it in or anything, you know. You can jot something down and just think, how did you come to know the difference between right and wrong? Describe something you remember learning about the difference. Now try to name something you know about this difference, but you don't remember how you learned it. If you do something wrong or bad, what makes you responsible for doing it? Or in what circumstances would you not be responsible? And then describe how responsible you were as a person at age 17, 14, and 10. Just do your best. Think about, how much you were able to reason about right and wrong, make free choices, and care about your impact on others at these different ages. So just take a few minutes to think about any or all of those questions, and then we'll talk about it for a few minutes before I wrap up. Okay? All right, it's been about 2.5, 3 minutes. Does anyone need a moment to finish a thought? Or should we just... Does anyone... Yeah. Sarah's going to bring you the mic.
And while I'm bringing it, I think for me the exercise illustrated how little I remember, which also kind of makes your point.
Yeah, I was just thinking about things I had been socialized in thinking as right, and then growing up and thinking was wrong, and then vice versa. And then also seeing, in my, immediate family and so on, close persons that know something is wrong, but can't accept it or acknowledge it. Otherwise, it would be like some sort of unraveling of the self or imploding. So, yeah.
Thank you for posing this question, Jill. When I started thinking about it, I thought of the traditional faith, family, home, upbringing, all of that. But then I started to think about my formative years in the classroom and other social publics, like spaces. And coming along in the United States in a very particular racial context, I also remember when there were issues between my classmates and I, right? I remember this little white boy poking me during reading time. And he was so insistent on making me uncomfortable and taking delight out of distracting me from what I loved, which my classmates knew was school and the learning environment, that when I turned around to say, cut it out, right? Stop, we're in 5th grade, grow up kind of thing, the teacher singles me out and takes away my recess, right? And so that whole idea of very early in the formative years of particular children and the bodies that they're born into a certain world and context, early on sort of adding that layer of feeling criminalized, right, in your formative years, that there's a weight on you to perform a certain way in society outside of your home, that extra eyes are on you and sort of, legislating or sort of policing how your body functions. And if you step out of line, like any other child would in those formative years, your sentence, right, or that criticism coming against you, it's going to fall a little harder on you than others. And that makes you feel othered, right? So that kind of gets incorporated into how do I think about right and wrong? How does my right and wrong even deviate, right, from those around me who might have the privilege of thinking about that question a little differently? So just wanted to point that out as another perspective. Thank you.
Yeah, thanks to both of you for that. Is there maybe one more person?
Thanks, Jill, for that question to reflect. So, in my reflection, I just remembered when I was growing up in Nigeria, and there's one popular weekly soap opera that we watch on the TV, and at the end of the soap opera, it will say, "Life is a teacher. The more we live, the more we learn," which means that as we age in life, we learn new things, we change our viewpoints. And so the things I learned or I thought appropriate at 10 will not be appropriate at 17 or appropriate at age 14, or maybe scaling the walls, friends to go and party at 14. I can't do that at 21 again, you know. Those choices will differ. And also it brings to mind my reflection also this idea, which I think is in the medical literature, that it's at age 25 that our frontal lobe is fully developed, and that is when we become full adult, when we can make rational thoughts, you know, decision, and so on and so forth. And then the last reflection I have from this question is also the problem in international law or even national law to determine when you are an adult or you are a child. Some international law will say 15, some will say 18, and even in national laws, it varies all over the place. In northern Nigeria, they will say as from age 12, you can marry. As from age 13, you can marry. In some Western legal traditions say no, as from age 18. And then if you have a mental infirmity, you are still deemed a youth till maybe 25. So again, those are some of the things that just came, you know, popping in my head. Yes.
Yeah, thanks. Oh, Alphonse, did you want to add?
Thank you. And I think something that you can pick from what you're saying is that age alone shouldn't be the determinant. Because given your background, at 10, you might think differently from someone who is 10 from another area. So 10, 14, 15, 17 doesn't mean a lot in terms of your capacity to know what is wrong and right.
Yeah, and I see Wumi wants to.
Yeah, mine is a bit to trouble this notion of responsible. So when I saw that, I thought, what is responsible? Are critical legal scholars responsible? I don't think so. In the sense that...
That's what comes next, by the way. So we don't have to...
Yeah, so I was thinking within international criminal law and the literature, if you think about the word responsible, if you're not sticking to that narrative, then the truth is we're all not responsible in this room. So I was thinking about that question of responsible, and I couldn't even come up with any.
Yeah, no, and I think that is definitely the right way to go with this. It's complicated, right? So then I was going to add this. Do you think Dominic Ongwen was able to make responsible decisions about right and wrong, given what you know, given what little you know about him? Was he able at age 10, age 14, 18, 28 and older? Why or why not? We can hold for a second. But what about this person? I put this up here kind of as a joke, because I thought we might need to lighten it up. But like, there's Jill at age 2. You going to trust her with a complicated ethical and moral decision? What about this one? That was the 80s, right? Like going to prom, that one, or this one. And the thing I wanted to point out is that, I don't know, I wouldn't really want, maybe her, but like definitely she's okay in terms of making a complicated ethical decision, but you know? And I also wanted to point out that in each of these pictures, I'm not alone, right? In this one, you can see my mother's hair kind of in the corner. In this one, you can see the suit of the person who took me to prom. Here, my arms around a friend. Here, I'm with the wedding cake of one of my best friends. And that is significant, right? Worlds are built by the way we dwell in them with other people, and whether we were lucky enough to have people who cared for us, who pointed out to us when we were going the wrong direction, maybe gently, maybe not so gently, who made sure that there was a place for us to land when we needed it, when something bad happened or when we made a mistake. And I just wanted us to consider whether we think that someone like Dominic Ongwen had those support structures such that he could come to a place at age 18, and I don't even know if I was that person at age 18, you know, who could make, in a situation where there are only bad choices available, what we would call the right one. Okay. And this is with me, this is not me saying that I know what the answer to that question is. I just think it's an important one for us to think about. Okay, so let me end by just making this a little bit more complicated, because I'm a philosopher and that's what I do for a living. So how do we determine what it means to find someone responsible for being one outcome of a complex history of ethnic and regional conflict based in disparities of wealth and political power that meant large numbers of people were, for generations, never effectively protected by their own government? If corruption, legacies of colonialism, disputes over natural resources, population displacement, internment in camps, constant vulnerability to attack, and reliance on humanitarian aid form the backdrop to the choices with which Ong Nguyen and so many others were faced, who is responsible for that? If we're uncomfortable finding children responsible for criminal actions, it's likely because we know that they may lack experience and developed capacity for judgment, and they deserve to be treated as capable of making better choices once they have those capacities. But judging the responsibility of child soldiers might start to show us something else too. If children lack an experience or capacity for judgment, we expect that they will develop those things. We think they will develop those things if they're well taken care of, mentored, supported, disciplined when necessary. But we also know that there are so many demonstrable ways that the world fails to provide that for so many people, regardless of age. And so I think that on top of everything else, what's difficult about the question of responsibility of children, what we fear when we look at it too closely, is that we'll find that we can't explain the responsibility of adults to ourselves either, at least not in the way we thought we could. And all of this is why, while I'm happy that international courts and tribunals exist, I also wish there was more international will to commit resources to prevention and recovery and look at deeper causes. After all, it might matter quite a lot to international order and to some of Ong Nguyen's victims that he was brought to trial and convicted, though this is also going to be appealed. It also might lead to some reparations awarded to affected communities. But it probably won't deter others from making the same choices, given the odds, especially when they're only given bad choices. It also won't rebuild the damaged infrastructure and communities or start to create trust where trust has utterly failed. And if there are, tens of thousands of former child soldiers in the region of northern Uganda who know that way of life but might wish to have another if given a chance, how does that come to pass? Especially given continuing crisis and competition for resources. What would we need to understand in order to do justice to the complexity of that situation? And can the ICC do anything with its processes, whether as they are now or modified, that would make a difference there? And I'll end with this. So often, a concern with laws and rights and trials ends up being a way of feeling that something has been done when really we've only scratched the surface of a problem. When I was in The Hague for the Ong Nguyen trial's opening arguments, I attended an evening talk on another trial, the trial of Ratko Mladic, who is a Serb commander who convicted of genocide against the Bosnian people. The talk was held at a place called Humanity House, which is a very Hague-sounding thing to have, right? There, a Bosnian documentary filmmaker voiced skepticism about what trials can do, and she asked us all to consider this. Imagine that there was a tribunal set up to hold responsible everyone who has ever known something going on near them was deeply wrong and did nothing about it. Is that also a kind of tribunal we need? What would it look like, and how would it operate? And I will end there, and it looks like we've got about 10 or 15 minutes for questions. I'm taking Sarah's job.
We're dealing with an ethicist here, and not only does that mean she's kept to time, but also that we need to be fair to her to give her the full hour. So you do have 15 minutes. So would anyone like to start?
Thanks. I'm going to be really annoying and ask you about something that you said you weren't going to talk about, but then I'll try and be less annoying by tying it back to Dominic Ong Nguyen. So I really struggle with the legal representative for victims, and I'm wondering, I was wondering, to what extent does it just create expectations that are bound to fail, while also just increasing the criticisms of fair trial rights of the accused? But I think then in the context of Ongwen, how, as like practitioners in transitional justice, how do we deal with the fact that even after the trial, a lot of the victims, as voiced by the victims' representatives, were not happy with even an argument for a mitigated sentence based on responsibility? And then to what extent are those potentially just the self-selected victims who believe in the justice system and that's enough for them? And so does it leave out other narratives, or is there something to the fact that actually Ongwen's victims still weren't happy with the fact that his responsibility could be diminished?
Great. I'll collect a few if there are other questions or comments.
Hi, Joe. Thanks for that presentation and for the insightful thoughts and questions you asked us to reflect on. I just want to, mine will just be more or less on comment because, again, I wear multiple hats all around it. And one of the hats I wear is that of being a prosecutor. And when you spoke about victims not being able to participate meaningfully in domestic jurisdiction, and that came to mind. Oh yeah, that was evolution, and that was what happened in most common law tradition. In civil law, definitely civil parties they do participate, but in common law it was a problematic thing that for years victims were excluded, their voices were not heard, and it was they were just witnesses only. And just like Florida said 2 days ago, is that all? And that was what came out in ICTR, ICTY, but largely a new movement of victim practitioners came on board. And in Canada, I know that Canada adopted what's called the Victims' Bill of Rights that gave victims for right, which is information, protection, participation, and restitution. And in my work, I do know that most times by the time I get back home now, I'm going to have a lot of voicemails from victims that says, oh, hey, what's going on about my case or this case? So there's this particularization, individualization of trials now. That's not the state acting for the victims, but the victims themselves telling the state what to do. So I pick up the phone and tell, oh, yes, this is where we are. Or even if I say I'm not going to prosecute a particular case, I have to provide rationale, the reasons why, to victims, which was not like that before. But one of the most important development around victim engagement in criminal justice system is that victim impact statement. It's really raw. When victims provide their own experiences and say, hey, this is it. This is what happened by raping me. You denied my dignity. I feel worthless. I feel this. That emotiveness or that comes from it is really powerful. That makes the judge to say, these are aggravating factors I need to consider. So that is that. And I think that was what happened at the ICC, where the civil and the civil tradition, legal tradition, and common tradition came out and say, lesson learned from ICTR, ICTY, we need a victim, common representative, legal representative for victim. That's just a reflection. In terms of my thought now, question now that we have tested out this idea of victim participating at the international criminal trial, what do you think will be, how can we make it? Is it better? Let's put it this way. What are your honest assessments around victims' engagement in international criminal court? That's what we are asking for. Is it good? Or is it an idea that we should just jettison and just kill it? What are your thoughts around that? Thanks.
Thank you. Now that I asked that first question in Professor Gever's lecture, now I'm full of questions. And I'm excited about that because it means, this space is meaningful to me as a fellow scholar. Jill, I wanted to also ask sort of more of a coming of age epistemology oriented question, right? I think Alphonse's point that he made, and even Wumi's question, just the way she phrased it, like, what is responsibility? Again, I come back to the personal and the political of the personal and my lived experience of, in the eyes of another party, external to my family life, cultural heritage, upbringing, there is an expectation of how, at this certain age, in this certain context, I should have behaved or known better or acted a certain way. And I wonder if we scale up to this international criminal law scope, where is there room for, conversation or consideration around how, childhood epistemologies or those coming of age epistemologies truly might differ between contexts. How can there be a sentence or a judgment, right, if there is that fundamental disconnect of what is a child? When does childhood or adolescence or innocence or coming of age thinking end and culpability as an adult or someone who is an aggressor or a perpetrator? When does that begin, if that varies at a fundamental sort of philosophical level between different societies? So I just wanted to pose that question. It's more open-ended, I suppose. I mean, I don't think there's a clear way to answer that here, but just wanted to ask that too.
Thank you.
Thank you.
All right, can I take these three? Already that's a lot, so I'm going to start by taking these three. So in terms of the victims' representatives, I think you're right to raise the problem of whether this just creates expectations that cannot be rewarded. I think Chris's talk this morning told us a little bit about what happens when an institution promises something and then doesn't deliver, as the TRC promised reparations that didn't come. And then to have the flip side be that this might be a problem with regard to trial rights of defendants, right? And then the victims not being happy with there being mitigation on the sentence. I think if we look at a broader range of victims in this case, the answer starts to, what's true starts to look a little different. I wish Ketty was here because I've heard her talk about this before, but from what I know from people who know better than me, in northern Uganda, there's a range of responses to this case. Some are like, good, he deserves everything he gets. Some are like, why does he get to be in The Hague wearing a nice suit and being fed? Some are like, send him back home and make him rebuild what he destroyed. And these are indications of really different attitudes towards what it means to do justice. In order to answer your question, I think I agree with you that what's happening with victims' representatives might be more problematic than helpful, even though I do think in an ideal world, the tradition of having parties civil, civil parties, victims being able to represent their own concerns at court is a good move for all the reasons I mentioned about the limitations otherwise. I'm not certain that the way the ICC is doing it is actually allowing that to happen for various reasons. And that kind of brings us to the question that Io posed, which is, what does this mean, or how should we think about practice? I mean, one thing about victims' rights movements is that it points us to what matters about people remembering that they have power outside of institutions. One thing I want us to remember is that any institution, the main point of which is to assert a kind of hierarchical power, is to make us forget about the power that we have. And so we should not allow that to happen. Most of the things that have changed for the better about institutions come from people saying, you know what, this isn't good enough. And even if you tell me that it is, I don't believe you. And that's a lot of changes with regard to victims' rights have happened because of that. One thing I think, and I don't know everything about every context, so I'm just going to talk briefly about in the United States. We get trained to think that law is going to solve every problem, even every social problem. And that's our fault. Like, that's our problem that we believe that. Part of it is our training. It's a way of saying, oh, we don't have to rely on what's really difficult about actually learning how to live with people who we don't agree with about everything. But yeah, I think moving away from expecting law to solve every problem while still demanding that it do better than it already does is the direction that we should be moving in. So I think Io said, like, well, what would be better? Obviously victim impact statements are a good thing that happen now. Victims' rights movements, some prosecutorial and offices now have, units that are for helping victims understand what they can and can't expect from proceedings, and that helps in lots of ways. So, yes. And then, okay, childhood across context. Basically, I agree with you, right? And that I did mention that very briefly, that like different cultures have different ideas about what it means to be mature, but law loves a universal standard. So it's easier to say 18, even though we don't even agree about that, than it is to say oh, look, this young child has now demonstrated that they can take responsibility for caring for children or getting the water or going to the grocery store, right? Whatever it is. But I do think that one thing we might want to do, I mean, one thing that I think that the ongoing case shows that has nothing to do with the ongoing case is this thing I pointed to, that what we worry about when we worry about the responsibility of children is that what it shows us is that we can't explain the responsibility of adults in the way we thought we could, which would be the Kantian responsibility way. Because there's so many ways that the world doesn't give that to people of various ages. The conditions where it's clear that they had the opportunity to make different choices and know enough about what the options were. So I think that if it could teach us that there might be more types of justice questions that have to be handled in a way that is more sensitive to context, like restorative justice principles, which also have their weaknesses, their problems, or even transformative justice, which is a form of justice that looks beyond those hierarchical institutions. In fact, tries to avoid involving them in the first place. Obviously, that's not going to be good enough when we're talking about genocide, but for a lot of other things, it may be. And it looks like we have 4 minutes, so I'll let Sarah decide whether.
Thank you so much, Jill, for your presentation. I was, thinking about your presentation and Chris's and where you started. And again, this is my politics hat on. And thinking about what you said about, the state. And I was thinking about responsibility as well as, what needs to be done, right, in terms of framing justice and enacting upon it, in terms of what is at stake. And I'm thinking about responsibility in terms, and this is drawing upon Chris's presentation, as people on the ground know who's responsible, right? It's not like it's not known, but there's a sort of covering up. And I'm thinking about, again, the ICC, this emphasis on individuals of particular origins, particular states, but not the international system, not the modern state as we know it, as a violent imposition, right? And so I'm thinking about, on the one hand, upholding the state as we know it, the modern state and its structures, as that being at stake. So the state, I loved what you said about, control, exerting control. And then responsibility as we don't want to probe too far in thinking creatively about responsibility and complicating that, because that would then bring into the picture entities that have to be protected because they protect themselves and they need to continue to reproduce their power. And so I'm thinking, more in terms of what's, at least, at a macro level, what's really the commitment, right, to unsettling what we've known up until now, right, and to basically undermining this sort of, power reproduction there. So it's more like a comment.
No, great question. That's actually a perfect question for me. I can answer it in a really philosophical way. The first thing I want to say is you're right that in many settings people know who's responsible, even if there isn't enough legal proof to show it. But I also just want to at least do justice to the situations where that's not true. And something like a truth commission can be meaningful because you're dealing with a state that has a history of disappearances and nobody knows what happened, who caused it to happen, where the bodies are. And for some people, it might be very important for, in terms of just feeling like there's closure. But even sometimes for legal reasons, you can't even inherit wealth if you can't prove someone is dead, right? So there's ways in which certain types of truth-finding activities might matter. That's to the side. In terms of rethinking our idea about responsibility, that also I think would benefit from us taking it beyond legal institutions. Legal responsibility is about individual criminal culpability, usually, and there's good reasons for that. Most of the reasons are good for that. But when it comes to all of us outside those institutions, just trying to live alongside each other, I think a lot of us, or maybe all of us, have to just admit that we have responsibility for things we didn't do. I opened up by saying I'm implicated in lots of colonial harms that are ongoing in the area where I live and all over the world because I'm from the United States, right? But it's also true that it's not even an idealistic claim I've just made. It's just strictly logical. If the world is full of inherited harms, that the people who did them are either gone or won't do anything about them, and you are a person who wants the world to be other than that and make sure it doesn't repeat and fix what already happened, then it just is true that you have to be responsible for things you didn't do and never would have chosen, right? And if we started to think about responsibility in that way, not in a way where you become like this self-harming person who doesn't ever, allow yourself pleasure, but in the way of just admitting that you can't wait for legal responsibility to take care of everything, that I think helps us step forward a little bit. Now let's go eat lunch.